Former President Thabo Mbeki and former Justice Minister Brigitte Mandla claim the blame for the more than a decade delay in prosecuting the over 300 apartheid-era cases emanating from the Truth and Reconciliation Commission should be placed at the door of the National Prosecuting Authority, which he says must be honest about why it failed to move on cases. Mbeki has upheld earlier denials of claims by former NDPP Vusi Pikoli that there was a political decision taken not to prosecute TRC cases and consistently faced pressure to drop further probes. The former head of state says the court can't make a determination without their version of events, which he claims will dispel a series of untruths.
This isn't a case where a witness can be called, whether he's a party or not, to have his version tested. This is all on paper. And if you're not given the opportunity to put your version on paper, your version doesn't see the light of day.
Never sees the light.
So, I mean, the applicants have chosen that course of action. They've chosen motion proceedings. I'm going to hear from Mr. Chaskelson on this particular aspect as well.
They have chosen that, and the facts on which they want relief are facts which directly implicate my client, and the court must make positive findings based on those facts that there was a breach of constitutional obligations by his administration and himself and Ms. Mabandla to warrant the grant of the relief.
Pikoli deposed an affidavit in 2015 wherein he claims that several members of the executive and in particular Mabandla continuously put pressure on him to drop the TRC cases and ultimately cost him his job. Mbeki and Mabandla's lawyer argued that too much reliance has been placed on statements made by Pikoli and the likes, and this can't go uncontested.
Denying us intervention in such circumstances would conflict with and unjustifiably deny us our right under Section 34 of the Constitution to have this dispute, or disputing these allegations which are the basis of the relief by the applicant, resolved by the application of law decided in a fair public hearing before this court. Once we are denied the right to intervene as respondents and defend ourselves against the serious and damaging allegations, we would not be able in future to relitigate the findings of this court against us. It is unlikely that a court of appeal would allow us the right to intervene to challenge any adverse findings by this court if we are denied the opportunity to defend ourselves as respondents before this court.
But the lawyer representing the families of victims argued that there's no need for the pair to form part of the High Court proceedings because they have not been cited as parties in the case and have the option of clearing up any inaccuracies before the Commission of Inquiry that's been set up by President Cyril Ramaphosa. In addition to this, they've argued that Mbeki and Mabandla are not the only ones who are likely to be named as possibly being implicated in the unexplained delays, and so the court must not allow for a free-for-all.
If you want to clear your name, if you want to set the record straight, you have remedies. The law of defamation is one, and the law of defamation has now developed so that you are entitled to come to court not to sue for damages in an action. You can come to court to sue for a declaration of falsity. So if the concern of Mr. Mbeki and Ms. Mabandla is that, well, we couldn't sue for damages in relation to these allegations because they're made in legal proceedings and qualified privilege attaches, you can always sue for a declaration of falsity. And the declaration of falsity it can't be answered by qualified privilege because it's not getting to a liability to pay damages, it's getting to establishing the truth to vindicate reputation. So the law provides remedies, but those remedies don't involve jumping into a dispute that isn't your dispute.
Judge Anthony Miller continuously impressed upon the exceptionalism of this matter, questioning the Foundation for Human Rights about whether the intervention of Mbeki and Mabandla is not to the benefit of the families who are seeking answers and justice for their loved ones.
Many of these people have died. They escaped justice through death. the person's best placed to put that information before the court, insofar as it's not readily available in government archives and other places, are those who were there. Now, yes, it would be ad hoc, but perhaps as ad hoc as the TRC itself, that it's something which must be allowed to see its course. And the monetary aspect of it is being dealt with nomina officio by the state parties. But wanting to hear from the mouths of those who were there, rather than by inference and books and articles and so on, and affidavits filed in different proceedings, isn't it the right of the families to hear directly from a person they obviously regard as being responsible for the predicament, or at least partly responsible for the predicament, what he has to say? Whether it holds water or not is a separate issue. I don't have to get involved in deciding that, fortunately. That's not for me to decide, but the principle of the right to know and the right to hear from the responsible party.
Judgment has been reserved with the ruling expected at the weekend. For Newsroom Africa on Channel 405, I'm Zianda Ngobo in Tshwane.